There are limits to presidential power, and that's the signal the Supreme Court sent to Joe Biden yesterday. The court struck down his vaccine mandate on businesses with more than 100 employees.
This major defeat for the president is a victory for conservatives who labeled the mandate government overreach. Gary Lane brings us the details.
The highest court in the land issued a split decision on President Biden's vaccine mandates. The Supreme Court ruling Thursday 6-3 against the president's major requirement that employees of larger companies get vaccinated, test regularly, and wear a mask while at work. However, the court let the smaller mandate stand for most healthcare workers. Senator Rand Paul told CBN News the court got it right on the employer mandate because he says it was clearly unconstitutional.
Even Biden, in advance of this, was saying it probably wasn't constitutional, so he did it anyway, which is kind of ridiculous. But no, I think this is really the court telling the president that there are limits to his powers.
The court made its decision based on constitutional merits. Justice Neil Gorsuch argued the vaccine mandate issue is a matter of who decides policy. The president's regulatory agency, the Occupational Safety and Health Administration, or OSHA, or other branches of the government. He wrote, quote, "The answer is clear. Under the law as it stands today, that power rests with the states and Congress, not OSHA." In an unsigned opinion, conservative court justices argued, quote, "OSHA has never before imposed such a mandate, nor has Congress. Indeed, although Congress has enacted significant legislation addressing the COVID-19 pandemic, it has declined to enact any measure similar to what OSHA has promulgated here." In their dissenting opinion, the liberal justices Breyer, Kagan, and Sotomayor argued that the court itself, not the executive branch of government, was overreaching by substituting its judgment for that of health experts. Republicans celebrated the ruling. But President Biden said he was disappointed that the court blocked common sense, life-saving requirements, grounded squarely in both science and the law.
This was a step that we announced and we had every intention of implementing because we knew that it was the point where putting in place requirements in the workplace would help get more people vaccinated. The good news is that a number of companies have already decided to do that and do that successfully.
On a 5-4 vote, Chief Justice Roberts and Justice Brett Kavanaugh joined the three liberal justices in allowing the vaccine mandate for healthcare workers to proceed. It's applied to providers receiving federal Medicare and Medicaid funding and affects some 10.4 million workers around the country. Medical and religious exemptions are still allowed. The president praised the court for that decision, saying it will save lives. Gary Lane, CBN News.
Well, with us now is Michael Schietzelt. He's the senior fellow at the Robertson Center for Constitutional Law at Regent University. Conservatives have called this government overreach. So tell us what would have been the implications if the court had upheld the directive?
Well, Gordon, first, before I answer that question, I just want to say last week that, we drew it up just like this, didn't we? The court came out and said OSHA doesn't have this power. And the reason that OSHA doesn't have this power is because it's simply not in the statute that Congress passed detailing OSHA's powers. And so if OSHA were allowed, if the court had come down the other way and said that OSHA has this power because of some vague or ambiguous language, then we worry about what agencies would do with that power. There's a lot of discretion with what agencies do. And if agencies can take ambiguous language and pass regulations that may arguably fit inside with that on major issues of policy, then they can do just about anything. And as Neil Gorsuch pointed out in his concurrence yesterday, he used the oft-quoted line that Congress doesn't hide elephants in mouse holes. We don't allow the agencies to pass major issues of policy on vague or ambiguous language. Congress must be clear. So it's important that the court came down the way that it did.
All right, so coming out of this, we should actually say this is a fairly narrow ruling, saying that this has to do with regulatory power as opposed to congressional power.
That's correct. It is a narrow ruling, but as I just said, there's a significant implications from that about the separation of powers and the famous law professor line, who gets to decide? That was how the conservative justices concurring led off their opinion. Who gets to decide this question? So while it is a narrow holding, it has tremendously large implications.
Well, let's turn to what they did approve, which is mandating vaccines for healthcare workers, anyone receiving government insurance through Medicaid, Medicare. So is that also a narrow ruling just because of the broad regulatory power enjoyed by the government in administrating Medicare?
It is a fairly narrow ruling, and if you look at the difference, it's kind of shocking. Well, I guess it's not shocking, but it's important to look at how the court leads off both of these opinions. And they lead off both of these opinions by talking about historical precedent. What has the agency traditionally been able to do? What has OSHA traditionally been able to regulate? And what has the Department of Health and Human Services and the Center for Medicare and Medicaid Services been able to regulate? So because DHHS and CMS, Center for Medicare and Medicaid, has been able to pass similar types of mandates before, the court allowed them to move forward on that. So it's really about the historical precedents that the agency sets.
All right, well, help me, I guess, make sense of it to people who aren't lawyers and walk me through it. The Fifth Circuit said this was a clear government overreach and they put a ban on it. Then the Sixth Circuit came on top of the Fifth Circuit and said no. It was a split decision, 2-1. But they said no, this is okay under the current OSHA law, and they moved the block. And now we come up to the Supreme Court, and it seems to be decided, frankly, on the political outlook of the justice. So help me make sense of this, because it seems like our court system has become political.
Well, that's a very interesting observation. I would caution against reaching the conclusion that the courts are political. I may get laughed at by people for that, but I think ultimately what this is decided on is on the basis of judicial philosophy. And it seems that the justices that were more inclined to uphold OSHA's mandate were more about deferring to the agency's authority to determine what is an occupational hazard and what is not. Whereas the justices that struck it down were more inclined to say, no, we get to decide how far the scope of your power extends. And if your power allows you to make these sorts of determinations, then perhaps we'll defer to those holdings or those conclusions. But we're not going to defer to your conclusion about how far your power stretches. So it's really a difference, not necessarily in politics, but in judicial philosophy.
Well, let's turn to the minority opinion on the employers with more than 100 employees. They're talking that the majority is ignoring science. Is there any irony to their questions during the oral argument that seem to be ignoring science? And is there any irony to looking at the current Omicron variant that's breaking through all the vaccines? Are they following science?
Well, it's certainly an unfortunate backdrop, but what we really should focus on is that the court was simply trying to defer to what OSHA was saying. The justices in the dissent were far more measured in their opinion than they were in oral argument, and they should be lauded for that, for making sure that they got things right, at least when they wrote the opinion. It is a little bit troubling to see the statements that were made at oral argument and the questions that were made, that we were operating on some demonstrably untrue premises.
Well, let's turn to the future now. Do you anticipate Congress, a bill coming before Congress to expand OSHA and actually put it into law that OSHA has this power?
Absolutely not. And the Senate's already voted to say OSHA doesn't have this power and shouldn't have this power. And as we talked about last week, the president has been squabbling with some of the more moderate centrist members of Congress in his own party. So it doesn't seem that I don't foresee the Senate particularly being willing to give this president more power when he's been, frankly, reckless with what he does have.
Well, Michael, thank you for the insight. Thank you. I've got to point out you were right a week ago. You handicapped the court with remarkable accuracy. You predicted that they would strike down the mandate for employers, but also uphold the mandate for healthcare workers. So kudos to you. Great prediction.
Well, thank you, sir. And I take no credit for that, though. This was a pretty easy case.
Okay.